Hi, Wes Scott from Kane and Scott. Today we're going to talk about what is a fraudulent transfer in a Chapter 7 bankruptcy. Um, a fraudulent transfer, and for our purposes, we're only talking about what the code says a fraudulent transfer is. There are some state court statutes that describe fraudulent transfers and conveyances and other actions that the trustee may pursue. But I'm only talking about Section 548 of the Bankruptcy Code. What is a fraudulent transfer? Again, the Bankruptcy Code gives trustees the right to claw back sometimes transfers that a debtor has made within a time frame prior to filing bankruptcy. And it's a little bit of a misnomer because fraudulent transfer doesn't necessarily mean that you intended to commit a fraud against anybody. In fact, a lot of times that's not the case. You know, if I sell my car, if I'm in debt and I file bankruptcy, in 6 months beforehand, I sold a car worth $3,500 to my cousin for $1,000, well, that's a fraudulent transfer. So think of a fraudulent transfer as any transfer you've made, whether you sold it, gave it away, or otherwise. Even if you sold it, even if you got money for it, where you sold it to anyone within 48 months prior to filing bankruptcy for less than fair market value. That's what we're talking about. So, you could have got $10,000 for the car, but you sold it to your cousin for $5,000. You purposely gave him a good deal, right? Because it's your cousin, right? That's a fraudulent transfer, and the trustee is going to be able to go after that transfer and try to recoup that value that your cousin got for nothing. If you get a fraudulent transfer action, call an attorney immediately. When the time is right, when you are ready, reach out to Kane and Scott. You're going to be so thankful you did. Have a good day.